So one of the interviews I went on was for a colleague of mine who couldn't go to the interview because they're located in another state. So he referred the clients over to me, and the case itself was not that difficult, but there were some issues that came up nonetheless. During the prep, during my prep of the clients before the interview, and also at the interview itself. So, some of the things that can happen when you're an attorney is that no matter how well you prep your client, you never really know or control what they actually say at the interview or at the court hearing. So, one of the questions that came up during the asylum during the adjustment application was whether or not my client had ever been arrested or convicted of any offenses. And, it turns out during the prep session that there were several incidents that happened that either kind of happened after the green card application was filed. And also, there were other incidents that weren't really disclosed um, to their attorney, and did not come up until I scheduled the prep session with the client. So basically, we had to kind of we had very limited time to get court records. So in this case, the client didn't schedule the prep with me until literally, a few days before the interview. So had to like counsel my client to try and get whatever documents they could to confirm, what happened, what were the charges, what was the final outcome. And, the client was able to get some documentation on short notice. But the other thing that happened at the interview was that the client turns out that there was a pending arrest, and the case was still, outstanding in criminal court. The client did not tell me about it during the prep session. It only came out during the interview because USCIS has access to this information. So the officer brought it up and said, well, did you forget to tell me about this incident, which had happened a few months ago? And the client's response was, um, kind of like, why are you asking me about it? So, the officer was really nice. I mean, they could have really taken it the wrong way. When immigration is asking you about a criminal arrest, you have to be upfront and honest, right? And answer all the questions that they ask you and not say, well, why do you need to know? Of course they have a right to ask. You're applying for a green card. So in this case, the officer was actually pretty experienced and she was actually very nice. And so the way she explained it to the client was, look, I already know about this incident. The reason why I'm bringing it up is I want to know how you're going to answer my questions. Are you being truthful to USCIS or not? Um, and that was a very tactful way of telling a client, you know, um, that it's not really about the actual answer to the question. You are expected to tell the truth at these interviews. When you apply for a green card and naturalization, um, and you show up for your interview, you may not know this, but everything that you say at the interview is going to be considered as a sworn statement, right? In fact, that's the first thing that immigration will do when they call you at the interview. Before you even sit down on their chair, they will ask you to remain standing, to raise your right hand, and the officer will put you under oath and ask you, is everything you're about to say the truth? Um, So after you take that statement, that sworn statement, if it later turns out that immigration thinks that you are lying or you're trying to conceal something or misrepresent, well, guess what? It's going to have a negative impact on your application. Even if, let's say, you um, were arrested for an offense, and let's say all the charges were dismissed. If you lied and you, deny that you ever were arrested or charged with anything, immigration can deny you for that reason alone, for not being honest, for lying, for making a misstatement, misrepresentation. So that happened at the interview. I kind of was really shocked because, the client did not mention this incident, number one, and number two, their reaction to it was not how I would want a client to react. Um, I think my client was really lucky because the officer said to me after the interview, she basically said, look, I'm not going to hold this against your client because ultimately these charges, from what I can see, they're going to be ultimately dropped. So I'm not even going to have you obtain the final disposition record for me. I'm going to go ahead and approve this adjustment application, which I could not believe what the officer was saying. Usually, when there is um, an arrest record, immigration always wants to see the certificate of disposition, which is the document from the court stating what happened to these charges. Were they dropped? Were they dismissed? Did the person plead guilty? If so, what did they plead guilty to? In this case, she basically said, I don't even need that final document. I'm okay with what I see based on, the background check records that they can access, and basically said, I will go ahead and approve your green card application. I think my client was extraordinarily lucky to have an officer like this. But in general, if you are applying for a green card and naturalization, and if you do have um, any kind of previous or existing interactions with law enforcement, you want to be forthcoming. You want to provide all the information that is requested on the form, and you want to have all the paperwork ready. The most important document would be the certificate of disposition. And here in New York, it's really easy to get this record. You just go to the court clerk um, in the court where the case was handled, and you request the original certificate of disposition. The court clerk will issue it to you. Make sure that it's the original. Most of these courts will have a stamp to confirm that it's the original that you're applying for. And most of them charge a fee. It could be $10 or $12, depending on the particular court. But you want to make sure you have the original. Sometimes a copy will not be enough for immigration. And that's kind of my general advice to anybody who ever had an arrest record. Because there are definitely questions on the adjustment form and on the naturalization form that ask, have you ever been arrested? What were you charged with? Where did this happen? When did it happen? What was the final result? So you want to be as specific as possible. Don't just say, I pled guilty, because sometimes you plead guilty not to the original charges, but to some other charge. Maybe the prosecutor um, agreed to let you plead to a less serious charge. So you want to be specific. And if you're not really sure what you pled guilty to, get the records. If you had a criminal attorney, ask your criminal attorney, can you remind me what happened? What did I plead guilty to? Or were these charges totally dismissed? Sometimes it's not that easy to figure out what actually happened by looking at a disposition record. So for example, in New York, where I am based, the certificate of disposition won't actually spell out what the charges were or what the final, conviction was. It'll instead just list the section of the New York penal law that someone was charged or convicted of. And if it's If it says a series of numbers, 240.20, you may not know what that means, but it's easy to find out exactly what this code of the penal law is. Just Google it. Um, because you want to be able to explain to the officer if they ask you questions, what exactly were you charged with? And if you don't know, you should find out and even bring a printout of the penal code stating what it is that you were charged with, um, or that you pled guilty to or were convicted of. Another question I get asked a lot from clients is, do I need any other records besides that final disposition record? Do I need to go and get a copy of the police report? My general policy is that I only submit the certificate of disposition to USCIS. Sometimes USCIS will ask for more records. Sometimes they'll ask for arrest records, police reports, the copy of the indictment. Um, and if immigration asks for those additional documents, should you provide them? I think it really depends on the circumstances. If it's a really serious offense that we're talking about, then you have to worry about, will immigration then use the information that may appear on the indictment or the, arrest record or the police report to then charge me with something that could make me deportable. So if you're not sure, I would say consult with an immigration lawyer. I think there have been times where I've had immigration issue these requests for evidence saying that they want additional documents besides the final disposition. And I'm pretty sure I've responded here a few times saying that it's not relevant. These are not needed. The bottom line is that my client's charges were ultimately dismissed or dropped, and that's all that should matter. So I'm not saying this will work every single time because sometimes there are crimes where technically immigration doesn't need a conviction record to find someone deportable. So, for example, if someone admits that they committed a particular crime, for example, if immigration has a reason to believe that someone is a drug trafficker, technically they don't need a conviction record to make that charge of deportability. If someone admitted to somebody at some point that they sold drugs, then it's possible immigration can use that evidence of that admission as a basis to try to place someone into deportation proceedings. So for something as complicated as that, if you're not sure about what records you are required to provide to immigration, consult with an immigration lawyer who also has familiarity with deportation proceedings. So very important because now that immigration is looking very carefully at almost pretty much every application that's being filed, I wouldn't be surprised if they are really focusing on these questions about, have you ever been arrested? Have you ever committed any crime for which you were not arrested? Have you ever been convicted? This is kind of like a very hot button area, right? They're looking to um, basically, it's all about enforcement these days. I hate to say it, but that's the focus. So you really want to, you know, to the extent that you can, you will really want to bulletproof all of your applications. You want to make sure that if you do go forward with applying for something, you want to make sure, okay, are there any risks in me going forward, putting myself out there and applying for this thing? Because once you file an application, then you're on immigration's radar, right? They have your name, they have your address, they have your contact information. So if you somehow become an ICE target, your home address is right there in the application, right? And they could very easily find someone if they go ahead and apply for an immigration benefit, whether it's a work permit, green card, naturalization, asylum, all of that. I think now is it's a time to be really, really looking really carefully at, do I want to file this application? Because the stakes are really high right now. The there's a high risk right now that anyone in the United States who does not currently have legal immigration status always should in the back of their mind be thinking, is there any possibility that, ICE could detain me? I'm not trying to say that to like scare people, but it is kind of a growing reality now.